be seated. Any further questions for the detective?
No, Your Honor.
None by myself.
None for me. All right, you may step down, detective.
Thank you, Your Honor.
People, next witness.
Your Honor, at this time, the people of the state of Michigan rest.
Okay, all right. What I'm going to do now is, you guys are getting your steps in, okay, if nothing else, all right? We're gonna take a break, and it's not yet lunch, okay? So take a break, go back to your jury rooms.
All right, so the jury, please.
Okay, let's be seated. That door to close. Any motions for directed verdict?
Your Honor, I have a motion to
Go ahead.
present on behalf of defendant Joshua Zuazo. Your Honor, Mr. Zuazo is charged with first-degree felony murder in count 1, and in count 2, unlawful imprisonment of Hussein Murray, and in count 3, unlawful imprisonment of Linda Murray. Your Honor, the first thing that I would like to address is the unlawful imprisonment of Linda Murray, because it's evident from the testimony that she gave that the person who bound her up and had her unlawfully imprisoned was a co-defendant, Mr. Hernandez. She never said anything about Mr. Zuazo apprehending her in any way. And furthermore, she testified that it was Mr. Hernandez who slapped her or smacked her or punched her when she didn't give the answers that he would have liked to have heard regarding where the money, the jewelry, and where the valuable property in the house was located. That seems to be a very clear case of unlawful imprisonment brought against Mr. Hernandez, but certainly not against Mr. Zuazo. And then, when we talk about the unlawful imprisonment of Mr. Murray, there's no evidence to say exactly who did all of that, but the person who is seen in the videos from the two different hardware stores, Home Depot and Lowe's, that's paying to buy these items that shows up on these receipts is evidently, there is clearly in evidence, Mr. Hernandez, who was taking money out of his pocket, and he's paying for all that. Who else is there? The second person has got either a bottle of Coke or a bottle of some sort of water, it's Gatorade water, something like that. He's not a participant in making any purchase. So those items that were used on Mr. Murray as well as on Mrs. Murray were purchased by the co-defendant, Mr. Hernandez. And so I'm asking for a directed verdict as to both of those counts, and then going directly to the first primary count, first-degree felony murder. I submit that there hasn't been enough evidence presented that would make Mr. Zuazo even be present in the place, in spite of the fact that Ms. Murray did identify Mr. Zuazo as having been present that day, because we have two other witnesses who testified, the police officers who spoke with her soon after this event took place. That was Detective Hagelin on Friday, the 11th of October, and then Detective Wiegman, who testified yesterday about 3 at least interviews he had with her. She didn't give a specific identification, and she didn't give the specifics about this, even the person. The only characteristic she gave about the second participant in the robbery was a person of average build, and that was it. Not 6 foot tall, nothing specific like that, even though that's what she testified to. So that raises the issue of identification on L. I'm going to be receiving an instruction on identification for the jury, but I'm asking here in this motion for a directed verdict that that charge be dismissed, directed verdict of acquittal as well because of the lack of identification evidence presented during the people's case in chief. I understand that the standard is that you have to view the evidence in the light most favorable to the prosecution. People versus Hampton and all of its progeny stand for that proposition, and I certainly am aware of it, and I'm submitting on behalf of Mr. Zuazo that people have met that burden, and it is for that reason I'm asking for him to receive a directed verdict of acquittal on all three counts. Thank you.
Okay. All right, thank you, Mr. McCarthy. Ms. Lofton, are you joining in?
Your Honor, but only as to count one. So I'm asking for a directed verdict only as to the felony murder count. Obviously, as Mr. McCarthy just stated, you're to view the evidence in the light most favorable to the prosecution. But when we look at the elements of first-degree felony murder, obviously the second prong there is the mindset that Mr. Hernandez had at the time. I do not believe that there was any testimony and that none can be inferred from the testimony that was provided. So I do believe, even in viewing the light most favorable to the prosecution, that count one as to felony murder should be a directed verdict.
Okay, thank you. Response by the people?
Judge, everyone knows the standard. This court knows the standard. And at this point in time, I don't believe any of these motions should be granted. The case should go forward to the jury. These are jury issues at this point in time regarding Mr. McCarthy's issue regarding his client, whether or not he was involved with Mrs. Murray's captivity up in the first story. I think, one, there's aiding and abetting, which would indicate that. Two, the defendant's DNA is on those duct tape rolls, as is the other defendant's. Not both duct tape that is down in the basement is found down there. And also, Mrs. Murray indicated that the defendant, Zuazo, wanted to put her in the closet before they left, along with the defendant. So I believe a lot of this is for closing argument. Obviously, they're both ready for closing argument, but to direct a verdict out, I don't believe it's appropriate this time.
Okay, thank you. The court does review motions for directed verdict to the light most favorable to the non-moving parties, which is here is the prosecution. First, we'll start with Mr. Zuazo's motion for directed verdict pursuant to all three counts. Count one, felony murder. Count two, unlawful imprisonment. And count three, unlawful imprisonment. The court finds that there is overwhelming evidence that Mr. Zuazo was a participant in count one, felony murder, as well as the unlawful restraints of Mr. Murray and Miss Murray. Of course, the questions as to whether or not he is to be found guilty or not guilty comes down to a question of fact to this jury pool, who is court is confident will make appropriate decision regarding that. It is beyond me, Mr. Zuazo, that you sat through this trial for this past week and would believe that there would be any chance that this court would direct this verdict in your favor. Same with you, Mr. Hernandez. The evidence is overwhelming as to count one, that you did partake in a felony murder, and the question is then going to be submitted to your fact finders, who the court is confident will make an appropriate decision as to their verdict. Both motions for directed are denied. Anything else?
Your Honor, at this time, I think that we could address the issue of the defense and what will be presented.
Sure.
I have conferred with Mr. Zuazo during the time that I represented him, and it is my understanding he intends to exercise his right to remain silent, and I would like to have him sworn so that he can inform the court of what that decision is.
Yeah, let's do that. Do you have any other witnesses?
The defense will not be presenting any witnesses.
Okay, Mr. Zuazo, stand up so I can get you sworn in, sir. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you. Put your hand down. Tell us your name.
Joshua Zuazo.
You want to ask? Or
Yes.
Go ahead.
Mr. Zuazo, you and I have been working together in your defense since I was appointed to represent you in October of last year, correct?
Yes.
And we have been diligently preparing for this trial that has been conducted during this week, correct?
Yes.
And one of the things that we have discussed is whether you would testify or not testify, correct?
Yes.
You understand that that's a choice that you make. It is not a choice that I make, correct?
Yes.
And you understand that in the event that you were to testify, certain items of your personal background, which are not in evidence right now, would be brought up during cross-examination that would impeach you.
Yes.
And you have made a decision about whether it is, keeping that in mind, that you will testify before the jury assembled to determine the facts in your case, correct?
Yes.
And can you tell Judge Polus what your decision is?
No, Your Honor, I'm not going to testify.
Okay, all right, and you need to understand then you have an absolute right to remain silent, you have a constitutional right to remain silent, and you do also have a constitutional right to testify on your own behalf in your trial. Now that you've made the decision not to testify, be confident that this court will read an instruction to your jury that states the fact that you did not testify cannot be used against you in this trial, okay? And at any time you change your mind, I think we're gonna likely take a break between now and when we come back potentially for your closing. If there's any point in time where you change your mind, let your lawyer know, okay?
Yes.
Okay, all right. Ms. Lofton?
Yes.
All right, I'll get Mr. Hernandez sworn in. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Put your hand down. Tell us your name.
Carlos Hernandez.
All right, your lawyer's going to ask you some questions.
Mr. Hernandez, I have been your attorney from the time that you were arraigned, correct?
Yes.
And we have discussed the fact of whether or not you would testify multiple times.
Yes.
Okay. And you understand if you wanted to testify, you do absolutely have that right.
Yes.
But also, if you did take the stand, you would be answering questions from me, but then the prosecution would have a chance to ask you questions. Do you
Yes.
understand that? And you understand also that you have a right to remain silent.
Yes.
And you understand that if you choose to remain silent, the judge would instruct the jury that they cannot use that silence against you.
Yes.
And you were present in voir dire when I actually asked the jurors if they would hold it against you. Do you remember that? Okay. Have you had enough time to make a decision whether or not you would like to testify?
Yes.
Has anyone promised you anything, forced you, or made you feel that you were unable to testify if you truly wanted to?
No.
Is the decision you're going to tell the court your own decision and your own free will?
Yes.
What is your decision? Would you like to testify or would you like to remain silent?
Remain silent.
Okay, and then same with you, Mr. Hernandez. You understand that by making a decision to not testify, you have a constitutional right to remain silent, but you also have a constitutional right to testify on your own behalf in your trial. The court would allow you to do that. Being that you told the court that it is your choice not to testify, be confident in the fact that I will read an instruction to your jury that the fact that you did not testify cannot be used against you. If you change your mind between now and the time before closings, let your lawyer know, and your lawyer will let the court know that you decided to change your mind, okay?
Okay.
All right, okay, thank you.
Your Honor, I do have one jury instruction issue.
Judge,
because
just
we're gonna-
one thing before we get to the jury instruction. I know you had asked Mr. McCarthy if he intended to present any other witnesses. I don't believe you asked that of Ms.
You're right,
Lofton.
you didn't. Ms. Lofton, do you intend on presenting any witnesses?
I do not.
Okay, all right. What's the jury instruction issue?
Your Honor, it's actually 16.4. It's the first degree felony murder. If you're looking at,
And this is in Hernandez finals?
Yes.
Okay.
so when we're looking at the actual Michigan model criminal jury instructions, that gives some instructions as to the use of the particular instruction.
What number is this?
16.4 is labeled
16.04, count one, first degree felony murder,
Yes.
okay?
If you're looking at the Michigan model criminal jury instructions, at the bottom, it says paragraph 5 may be omitted if there is no evidence of justification or excuse, and the jury is not being instructed on manslaughter or any offense less than manslaughter. Here, there has been no evidence that there was some sort of self-defense claim. I'm not asking for those instructions. I don't think 5 is appropriate with the facts and the evidence that have been placed on the record. As to number 6, the model criminal jury instruction states, use 6 or 7 where factually appropriate. 6 states, to establish an attempt, the prosecutor must prove beyond a reasonable doubt, and then it goes to detail that. There has been no attempt established. The evidence clearly shows that individuals went into the home, items were removed. I don't think there's an attempt issue here, and I think that attempt instruction is going to confuse the jury, especially when they're going to be reading this in conjunction with an aiding and abetting instruction. So I am asking that 5 and 6 be struck.
Your Honor, I would join with Ms. Lofton's motion and also advise the court that as a member of the Model Criminal Jury Instructions Committee, this paragraph 5 has been the object of discussion. It is based upon a finding in a Court of Appeals case that is now being reviewed by the Supreme Court, but the Court of Appeals ruling was that it has no business in any of the homicide instructions, because there's this not justified, excused, or done under circumstances to reduce the lesser crime doesn't apply.
I feel like that does apply on the premeditation standard, but I don't see how element 5 applies to this particular fact pattern.
Judge, I don't have any objection if the defense wants 5 removed.
Yeah, because there's been no evidence presented that the killing is not justified, excused, or done under circumstances that reduce it to a lesser crime. There is no lesser crime. I'll strike 5. Okay, so 6. Do you join in that as well, Mr. McCarthy?
I do, because I don't believe the evidence is attempt, given the fact that stolen property was found in Mr. Hernandez's vehicle.
In order to qualify as an attempt, the action must go beyond mere preparation to the point where the crime would have been completed if it hadn't been interrupted by outside circumstances. There is no evidence that suggests that anything interrupted this crime.
Well, I would believe to argue that if what some of the things Mr. McCarthy has indicated to the court about identification, it's going to be that those things interrupted his client from appearing at the scene. So that part...
Wait, say that again?
I don't think Mr. McCarthy, from what we've talked about, is going to agree that his client was there for this. So something interrupted his client from showing up to the scene to participate in this. I also don't know if there's going to be an argument that, well, at some point my defendant, whichever one we're talking about, decided to leave and not participate in it. So I think that should be left in there, quite frankly.
To leave during the larceny or to leave during the murder? Or both?
Well, it would be, since it's not a premeditated murder, there's not a preparation for the murder, but there is preparation for the larceny. And that preparation, as we've seen through the text messages, there's preparation for that larceny by him. And it's not that you can't prepare to do a larceny that then turns into a felony murder. So he's preparing for a larceny. So I think that instruction should stay in there.
Well,
Hang on 1 second, I'm just going to read it to myself again. Okay, well, so then I do understand what the prosecutor's saying. I think that this is what I want answered by the defendants regarding the portion of it that says things like planning the crime or arranging how it will be committed are just preparation. So we just heard an hour and a half of testimony, of text messages that talk about potential preparation or what the jury could see as preparation. This specific instruction says that doesn't qualify as an attempt. So the fact that those messages are going on in and of themselves is not preparation of a larceny. For it to qualify as an attempt, there has to be an action that goes beyond this preparation to the point where the crime has been completed. So if you, Mr. McCarthy, get up and argue and say, and I don't know if you're going to, and I guess we can take it under advisement until that point, but if you get up and argue to the jury to say, yes, my client was in those messages, they got him there, however, he never showed up to the house that day, that would indicate that there was potentially an attempt or mere preparation, which would be your argument.
You are correct in the sense that this is mere preparation. All those things that happened before October the 11th are indeed preparation. Whoever's doing them, whatever that preparation was, is a question of fact for the jury to decide.
So you want this instruction?
No, I don't. I don't think that that should be in there, because this isn't an attempt. This crime was completed by someone. My whole point here is that it isn't, and this is what the argument's going to be, it's not Mr. Zuazo. And I think that paragraph 6 should not be included as a part of the instruction, the same as I argued about paragraph 5 being out. And I think that that last half, and that was the thing that I was focused on, the things like planning a crime. One can plan something and not carry it out and not be a part of it, and that doesn't make them guilty of a crime, even if somebody else did it. If you're going to argue aiding and abetting, that's a different thing. And if you can establish that somehow or another the actual actor was being told to or put out there by another person who's the aider and abetter, that's a different circumstance. But that's not what we have here. Factually,
okay, so I'll
based
get
on
to you in
the
a second. So I understand that point. The hypothetical that I think that then this could apply for is a situation of where somebody is attempting to go into the home, but then are stopped at the door, and their attempt is to do it, and then it results in a felony murder because that was the person's attempt to do it. But here we've seen evidence that the home was ransacked, that whoever was in that home, in fact, did commit a larceny.
And that's the point, because the instruction itself in paragraph 4 says the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. So if he's going to say his guy didn't show up there, and let's say they believed it, he could still be guilty of first-degree felony murder from all the stuff he did leading up to that, because he is helping. That's the preparation.
Aggravating and abetting.
And that's for the jury to decide by applying the facts to the law, but if you don't give the rest of the law, they won't have that ability to apply it. So that's a jury question of whether it is or isn't preparation, whether he is or isn't there. So he could still not be there, and yet be guilty of first-degree felony murder.
But I guess why are you believing that an attempt instruction applies at all? Because the next element here says the defendant must have been either committing or helping someone else commit the crime of larceny.
Yes.
So that could apply to both.
Regarding Mr. Zuazo, he is helping someone else commit the crime of larceny from everything we just saw in the text messages. So
7 is good.
Well, I don't think we were even talking about 7.
But I'm saying
Yeah.
7 is what really describes, I think, the element or the instruction that the jury should focus on.
Judge,
Yeah.
let me say this,
Sure.
okay? My first concern in this case is protecting the record, okay? My theory is not going to be that he abandoned it. My theory is he was going to be there. If the court wants to strike 6, I'm fine with it. If I don't want that to be an issue on appeal, that we're worrying about something that I'm not even going to argue in closing that he abandoned it, I'm going to say he's there. That's not. So if you want to strike it for safety's sake, I'm fine.
I think it's for like I wouldn't be striking it for safety's sake. If I struck it, it would only be because I think it would be confusing to the jury when they're back there deliberating. But what's your position, Ms. Lofton?
Your Honor, in reading the actual model criminal jury instructions, it says use 6 or 7 where factually appropriate. So I think the instruction is
Let me
telling
see
us
that, bring that
we
up.
are not to use both. And I agree with the court. I think 7 is very appropriate.
It is in correlation with 8.1 and 4 and 5.
So the user note says paragraph 5 may be omitted if there's no evidence of justification or excuse, and we've done that. And then it states 4, third, that when the defendant did the act that caused caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove the following elements. The defendant took someone else's property. The property was taken without consent. There was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. For that, at the time the property was taken, the defendant intended to permanently deprive the owner of the property. So that goes into explanation as to the removal of any properties, essentially the mindset versus what is actually taken out of the home in this factual scenario. And then it says use 6 or 7 are factually appropriate. The court is going to find that 7 is more factually appropriate and that the defendant must have either been committing or helping someone else commit the crime of larceny. To help means to perform acts or give encouragement before or during the commission of the crime that aids or assists in the commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. And if this is on review to the higher courts, the court is referencing criminal jury instruction 16.4, first degree felony murder out of chapter 16 homicide out of the Michigan model criminal jury instructions. Okay, all right, anything else?
Only just to make sure I've got it right, number 5 is being eliminated as well.
Yeah, 5
Thank
is
you.
struck and 6 is going to be struck, so.
And 7 will be renumbered as 5.
And 7 will be renumbered as 5. So if we can do that to get the final instructions up to date for the jury.
Judge, let me ask you on that.
We'll do it.
Okay.
Mhm. Yeah, at this point we'll do it if there's any changes. What else?
I believe that's it.
Okay.
And that's it for
So
the
now it's 12:20. When we go back to our cheat sheet of whenever we were gonna do everything. So we need to bring back both jurors right now because you guys are gonna rest. Is that right?
Yes, Your
Counsels? Okay, and then we're gonna break for lunch for everybody, I think, at
Yes,
this
sir.
point. Okay, all right, let's do that. Please be seated. Mr. McCarthy, any witnesses on behalf of Defendant Zuazo?
No, Your Honor, the defense rests.
Thank you. Ms. Lofton, on behalf of Mr. Hernandez?
Your Honor, we have no witnesses, defense rests.
All right, ladies and gentlemen, so at this point, what we're going to do is give a lunch break. It's just almost 12:30. One group of you is gonna get a longer lunch break than the other because we're gonna try to resume back with closing arguments. Kind of like we had done with openings, those were done at separate times. That's what's gonna happen with closings, all right? So I can only anticipate how long I think it's going to be, so please bear with me. I will make sure to let staff let you know if it's gonna be longer than that. But because we all need to take a break right now, I am going to allow jury B, that's you guys, to go to lunch now for, it is 12:30, let's say, to be back in your jury room for an hour and a half, all right? So be back in your jury room at 2, okay? So 2 p.m. for jury B. And then jury A, does 30 or 45 minutes sound okay for a break? Is that good? Long enough for a lunch? Okay. So then it's 12:30. Let's say be back in your jury room by 1:15. Okay? All right, thank you.